So we're here today to talk about the latest Supreme Court request to the Supreme Court to hear another appeal stemming from the Apple versus Samsung litigation. I suspect this is long-running litigation that many of you are familiar with. That's been going on for many years. It's produced multiple verdicts, a complicated set of appeals, a previous Supreme Court decision involving design patent damages, and now, several months ago, Samsung has filed another petition for certiorari to hear an appeal involving issues of obviousness and as well as when a patentee can get an injunction against an infringing defendant. So in 2007, the Supreme Court, in its bedrock case of KSR versus Teleflex, said that for over half a century, it held that a patent for a combination which only unites old elements with no change in their respective functions obviously withdraws what is already known into the field of its monopoly and diminishes the resources available to skillful men. I'll change that to skillful people. It went on to say that granting patent protection to advances that would occur in the ordinary course without real innovation retards progress and may, in the case of patents combining previously known elements, deprive prior inventions of their value and utility. So this is really obviously a foundational question in patent law. How do you determine, and how do courts determine, when an invention is too obvious, too much of a trivial or minor modification or advancement over the prior art in order to actually qualify for the patent monopoly? So in this case, there was a verdict, an infringement verdict in the district court against Samsung. Samsung appealed that to the Federal Circuit, and in the panel decision in the Federal Circuit, it actually won on the question of obviousness, and the panel decision held that the patents involved, there were two patents, including a patent covering the slide to unlock feature in iPhones, only covered, and this is a quote, ordinary, indeed trivial innovation, and therefore did not qualify for patent protection. In a somewhat, I think it's fair to say, unusual procedural history since then, the full Federal Circuit en banc actually reversed that decision and held that the patents upheld the original jury verdict, finding the patents non-obvious. And in the process, I think raised some very fundamental and wide-ranging questions about how courts decide obviousness and the substantive law of obviousness itself. So to talk about these issues today, including whether or not the Supreme Court should and will actually take up this case, we have a panel of experts. I'd like to briefly introduce them. So starting on my left, first we have Derek Dahlgren. He's a patent litigator and patent prosecutor with the firm of Rothwell Fifth, here based in Washington, D.C. To Derek's left, we have Ellen Schrantz. Ellen is a senior director of government affairs and counsel at the Internet Association, which filed an amicus brief in this case in support of the petition for cert. To Ellen's left, we have Carl Cesari. Carl is an appellate litigator based in Dallas, and he represented the Hispanic Leadership Fund and the National Grange in another amicus brief filed in this case. And then I believe on Carl's left, finally, we have Matt Levy. Matt is a counsel with the law firm of, it's Wiley Ryan, did I have that right?
So I'm consulting counsel, which is, it's a part-time gig.
Consulting counsel with Wiley Ryan, and he's an expert in patent law and software patents in particular. So a lot of expertise up here on this panel, and looking forward to hearing the discussion. So I'll turn it over to Derek to get us started.
Sure. So I think what's important to note first before you get into the substantive legal issues is the kind of odd procedural path that this case took. So what we have here is a cert petition from an en banc decision of the Federal Circuit. Now, en banc decisions are reserved for matters of exceptional importance or to maintain uniformity within the court and the patent laws. Here, despite the high bar for en banc procedures, the Federal Circuit did not invite briefing from the parties or argument or even stakeholders. So you have essentially the Federal Circuit taking a case and deciding it without any additional input from the parties. Highly unusual. And I guess on its face, it seems to be a situation where the en banc majority of the court simply disagreed with the panel. So all three original panel members dissented from the en banc decision. And they actually offered to remove what was supposedly the basis for the court taking the case en banc, which was the reliance on extrajudicial evidence. Now, this is somewhat remarkable, too, that the conflict that the en banc court identified was with the Teva v. Sandoz decision, which actually Apple never even raised in its petition for rehearing en banc. So it's a very unusual case that I think there's tension with kind of notions of due process, with the court following its own procedures. And I think from the court's blinkered view of these issues, it's perhaps not surprising that it may have erred on some of the substantive legal issues. So on the merits, the petition challenges three aspects of the en banc majority's opinion. The first is injunctive relief and what type of causal nexus is required in order for a court to find that injunctive relief is warranted. At the district court, Apple was initially denied an injunction. On appeal, the Federal Circuit reversed, finding that only some connection between the patented feature and demand was required. This lowered the nexus requirement that had uniformly been part of the analysis for injunctive relief, I'd say for hundreds of years. Now, the Federal Circuit, the en banc majority, also created, I think in effect, a presumption that the public interest always weighs in favor of a patentee when deciding whether or not to issue an injunction. There's also an issue about infringement that was raised in the petition, but I think what we're going to get into in most detail here is the third issue, and that's the issue of obviousness. And specifically, there's two aspects to the en banc majority's decision that are somewhat concerning. So the first is the Federal Circuit's reliance on the motivation to combine requirement and using that as a proxy for the ultimate determination of obviousness, which is a legal conclusion. And the second is the proper role for what's called secondary considerations or objective indicia of non-obviousness. The Supreme Court has yet to speak on any significant detail about these secondary considerations, except to note that they are secondary. They might be considered or can be considered in appropriate circumstances. Yet the en banc majority opinion here noted that they must be considered in all circumstances, and they may be the most probative, which calls into question why did the Supreme Court refer to them as secondary. So just to give you a brief background on obviousness, this may be useful to help clarify some of the issues presented in Samsung's appeal. So as I mentioned before, obviousness is ultimately a legal conclusion that's for the court to decide, not for the jury. Now, it's predicated on four subsidiary factual issues: the scope and content of the prior art, the difference between the prior art and the claimed invention, the level of skill in the art, and what I referred to before as these secondary considerations. Now, getting back to the issue of legal versus factual, this is critical because it goes to both who decides the issue, the court versus the jury, and also the level of deference that is given to that decision on appeal. Factual findings from a jury are given a much more deferential standard of review than legal issues, which are reviewed de novo. So under the obviousness inquiry, the Supreme Court looks at the factual gram factors, but then requires the court to make the ultimate legal determination as to whether a claimed invention would have been obvious to a person of skill in the art. So under Supreme Court precedent, at least, the final decision rests with the court as opposed to the jury. So turning to the en banc majority's decision, focusing on the obviousness inquiry, What we have here is where the original panel reversed the district court and found that Samsung had established that the two asserted claims, the slide to unlock and the autocorrect claims, were obvious. Now, for, I guess, the record, even on the en banc majority opinion of the court, they admitted that all the elements of these claims were present in the prior art. But because the jury had found that the claims were non-obvious, what the majority of the en banc Federal Circuit did was assume that the jury found there was no motivation to combine and that secondary considerations weighed in favor of non-obviousness. Now, in doing so, I'd say it erred in three respects. First, it elevated the motivation to combine inquiry far beyond anything required under Supreme Court precedent. I mean, KSR specifically rejected the argument that a specific motivation is required. Instead, it is enough, for example, if it's a solution to a known problem. Second, it allowed the jury's implicit fact-finding. Again, this was not an explicit fact-finding from the jury, an implicit fact-finding to essentially decide the ultimate question of obviousness, which is, again, a legal question that is for the court to decide. And third, it elevated the role of secondary considerations from being secondary, I'd say, to being primary. Again, noting that these considerations are the most probative and that they must be considered despite Graham and KSR, the two Supreme Court cases touching on obviousness, noting that they might or can be relevant under appropriate circumstances. So touching, I guess, on the secondary consideration issue, here we have a record where the parties essentially agreed that all the elements of these claims were present in the prior art. There was no argument that there was unexpected results based on the combination of these different elements. And the problem that was to be solved by both patents, the slide to unlock and the autocorrect, was known. So despite this, the en banc majority found secondary considerations weighed in favor of non-obviousness. Now, this calls into question I think a lot of issues. Is a prior art product patentable just because it's commercially successful, widely copied, or praised? What is the required nexus between showing these secondary considerations, praise, commercial success, and how do you link that to the alleged improvement that the claims cover? Here, what we have, for example, is Steve Jobs presenting the iPhone, and doing so using the slide to unlock feature. He received a round of applause, and the court gave that deference, saying that that weighed in favor of non-obviousness. Flimsy evidence like that calls into questions I think the court's analysis. So I believe that the en banc majority opinion will have some pernicious effects. So first, it will turn the obviousness inquiry essentially into a factual question that's predicated on the alleged motivation to combine. So it will send that back to the jury as opposed to the court. It'll also elevate secondary considerations so that even trivial incremental advances may be granted patent protection, notwithstanding the slight difference in scope with the prior art. And this is particularly troublesome in today's emerging markets, where you have similar designs and functionalities across technologies that are combined. What the court found here was that for the slide to unlock patent, that one reference was a mobile device, but the other was a wall-mounted unit. And because it was wall-mounted, it wasn't really relevant for purposes of obviousness, and they discounted it on that basis. And with respect to the second patent, they found that autocomplete was different than autocorrect. So one reference disclosed completing the word when you start typing in the text, whereas the other one addressed correcting the text. So the result, I think, here is that by lowering the bar for non-obviousness, there's a real risk that patents will issue that don't deserve patent protection, that there will be additional litigation, and ultimately it's the consumers that are going to bear the brunt of this, because they'll be subsidizing the litigation costs for innovators and suffering as a result.
Great, thanks, Derek. Next, we'll hear from Ellen.
So, like Ryan said, I'm with the Internet Association. We're a trade group here in DC representing 41 internet companies. So everyone from search engines, social media platforms, e-commerce sites, sharing economy, gig economy companies, streaming platforms. If it's an app on your phone, they're probably our member company. And we filed an amicus in this case because, and I think I don't want to repeat the fantastic work that Derek did outlining this case in a much better way than I ever could, but when we as a trade association look at patents and evaluate cases and legislation and what the PTO is doing, we're always looking at how do we ensure that patent law is promoting innovation for the benefit of the public? What is the public interest in making sure that innovation is moving forward rather than being stifled by removing from the public domain things which should not be otherwise? And so when we talk about non-obviousness, that factor is critically important. I can't highlight enough how important it is, and in KSR, the court in fact highlighted how important it was, because what happens if you impose economic restrictions in the form of exclusive rights on ordinary inventions, things that would be invented or done otherwise without the inducement of a patent, what you're ultimately doing is taking away benefit to the public that should be there otherwise and moving forward in innovation. And so when we look at this case, I think that it is hard not to get lost in very complex legal terms and standards, and but ultimately it comes back to the fact that to us, and as laid out in our brief, what the court essentially did was take a legal determination of obviousness and make it into a factual determination for the jury, and then just presumed that the jury resolved facts that it wasn't even charged with solving in the first place, and that by doing that, lowering that bar for obviousness, there is going to be a very substantial effect across many industries, not just ours, but I think Carl and Ryan and Public Knowledge's brief did a great job laying out the wider effect of that. And so when we talk about legal standards and legal versus factual determinations and the level of importance of motivation to combine, what we ultimately come back to is, are we lowering the bar? Are we lowering standards for determining something that should be given the highest level of importance when considering patent validity? And so I don't want to spend too much time kind of outlining again what Derek did a great job doing, but just to say that we are very hopeful and think the Supreme Court should take a look at this, that it is very much primed to it, that in their decision the court even reserved legal issues to the side, and I think KSR was the only opinion on obviousness in something like 40 years or 30 years. And so given the speed which the marketplace is moving and the complex issues across circuits and court decisions on obviousness, as well as the very strange procedural history here of there not even being a briefing ahead of the en banc decision, this really is primed for Supreme Court consideration post KSR and the court's odd procedures and substantive effect that their decision would have.
So I think you might be drawing the conclusion from your invitations today and from hearing the speakers on introductions that I'm the redheaded stepchild in the room, because my clients are very different from everybody else here. We have tech companies, we have computer manufacturers, we have intellectual property experts, and we have minority and rural advocacy groups. And it might seem strange that we might jump into a case about smartphones between Apple and Samsung. But to the contrary, this is an important issue for our clients, and I think my clients were very forward-thinking in getting involved in this case and urging the court to take this case, because what unites my clients is that they are the Davids to the Goliath of the world. They are always finding themselves behind barriers. They are consistently trying to break into new territory and advance their communities from disadvantages that they've suffered in the past, whether that's because of accidents of geography or because of pernicious discrimination in the past. And they look forward and they see the path forward for their communities is tied to innovation. My clients' members include people who have patents. My clients also include people who are trying to break into markets dominated by patent holders. They've got to compete against patent holders. They've got to find territory where they can innovate that isn't covered by patents. And so they're intrinsically linked with the innovation economy, whether that's the design of a plow, the design of a drone to cover your crops, and it comes right into smartphones because they make the components that go into smartphones. And my clients also represent the interests of people who are the consumers of smartphones, because smartphones and those kind of connective technologies are vital for everybody to have. And rural people and minorities are lagging behind in getting them, and they disproportionately turn to smartphones to get them. So we're pretty well situated in this territory, and this is an important issue because the issue of obviousness, it's not a dusty academic treatise. This is one of the most practically important issues of patent law out there in the world, because every time a person goes and takes a patent to a bank and says, "This is my only asset, give me a loan," every time somebody receives a threat of infringement from a competitor, they have to evaluate the validity of the patent. And the obviousness question is ultimately is there any invention in there at all? Or is it just cobbled together bits of other technologies or other things that are already out there in the public domain? And is it the kind of thing that took some kind of inventive spark to produce? This is an intrinsically legal question. And the basic flaw that gets to the problem in the Federal Circuit's opinion is that it really does turn over, and it does so sometimes by claiming not to. But the ultimate effect of what it does is turn over obviousness to a jury, as we've kind of been talking about, and give great deference to the jury's findings, yay or nay, on obviousness. That's bad for a variety of reasons. For one thing, there's a certain arbitrariness to giving things to a jury. You're asking ultimately the jury to evaluate the state of the art in technologies as diverse as biotechnology, space telescopes, and evaluate whether this is a step beyond what was already there. It's hard to do. And you're also asking them, is the quantum of that inventive spark enough to be deserving of a patent monopoly, which is intrinsically a policy-laden question. It's a question that really gets at the core of determining something. Like, you have to look kind of behind the letter of the text of the Patent Act to kind of get at whether or not that you've met that territory. And so deferring to juries creates a lot of problems. I mean, it runs the risk of allowing a lot of really obvious inventions that may not be obvious to a jury to be validated. It also runs the risk of invalidating some good inventions. So this deference harms both patent holders and their competitors alike. And it becomes very problematic when you think about how these could be used in the real world. Competitors can abuse now very obvious patents. I mean, we're talking about slide to unlock, which is, and we haven't really gotten into this yet, but the slide to unlock feature was literally out there in another product. The idea of sliding to unlock the phone, it was in another touchscreen product. And then that was combined with a paper that had outlined the idea of using that little unlocking icon to kind of trace the unlocking. And the court kind of bent over backwards to uphold the jury's findings that wasn't an obvious invention, even though it's literally out there in the world, and it's literally just combining two things together. It doesn't produce anything unexpected. And that gives you a flavor for where the Federal Circuit is taking obviousness. And And the practical significance of that is not only to produce bad jury verdicts and the incentives that that produces, but patent law depends upon a regime of rules. Because if I'm to evaluate, patents don't operate in the courtroom. They operate in the real world. So when I take a patent out in the real world and I'm trying to evaluate its existence, its validity, what it covers, I need to know a series of rules. I need to know with some certainty if I'm going to turn this over to a bank. I need to be able to know how to convince them that it's a valid patent and that they should stake their money on my product. If there's nothing beyond, well, I mean, it looks like an invention to me, but I don't know. A jury might think differently somewhere down the road. Or, Derek was talking about crowd reactions. To raise crowd reactions to a kind of primary place in determining obviousness is a real problem, because you don't know the reaction of the crowd when you're looking at a patent, especially if no one has produced this product in the world and it's just a naked assertion of a patent. And what does a crowd reaction really mean? I mean, yeah, people love the iPhone, but I don't know if you've ever been to an Apple event, but they clap at everything. So I mean, what's meaningful about that? And to make those things very significant. I mean, it's one thing for an industry reaction or market reaction to resolve a very close case. But to take a case in which you have a product which is literally slapped together pieces of already existing technology. By the way, in every other similar jurisdiction that has a patenting regime like ours, slide to unlock has been invalidated as obvious. We are the lone contender because a jury said so. That is not a workable regime for patent obviousness. And I think that, as I said, there's an arbitrariness that cuts both ways. It harms both patent holders and their competitors. Just think of the competitive environment that you'll produce if you allow these kinds of obvious inventions. It reduces the field available to people to come in and does so in kind of pernicious way, because they can, if the more they know about the industry, the more they're going to be lulled into a false sense of security about their ability to enter territory without running into a bunch of patents. They're going to say, well, everybody knows this. But that's no longer a reason not to do a patent search. You can't trust your intuition. If again, a jury might eventually find that, slapping stuff together, it's really cool, so that's an invention. This is of course harms our communities the worst, because we have trouble finding funding. We need stable patent rights. We need to be able to convince reluctant lenders to give us money and reluctant investors to give us money. If we can't stake our property on something solid rules, and solid rules to be imposed both by juries and by people evaluating this IP in the marketplace. And if we're a competitor and we're faced with an infringement, we have to plan our entire business around one decision. That is, do I leave the marketplace? Do I design around this? Or do I ignore this patent? I'm staking everything I have on that. I need to be able to do something more than, I don't know, maybe a jury will find it's valid. And it also makes patents more effective anti-competitive weapons. And this is something that we haven't talked a lot about today, but it combines with the reduced standards for injunctions that are also at issue in this case. Patents are great, but patents get abused. And they get abused by patent trolls. You can talk about patent trolls all day long, but they also get abused by competitors who push them farther than their justified being. And when you do that, a person who is unable to make a good, valid evaluation of the patent's validity is in a very hard situation. And sometimes they're going to be de-incentivized beyond what they should be, and because they're going to be afraid of being stuck with an infringement suit or an infringement verdict. And both of those things contribute to an unfair environment for everybody.
Matt, thanks.
Thank you. I'm Matt Levy. I used to be patent counsel at the Computer and Communications Industry Association. I moved out a couple months ago to go it on my own. I'm doing some part-time stuff at Wiley Ryan, but I'm also, doing some independent consulting, doing code review for cases, things like that, freelancing. But I wanted to talk, so we've gotten into the the specifics of the law, but I want to take a step back and talk about what I think is really going on here, which is, it's important. Apple is not the only party that's guilty of what I'm about to describe, but certainly they're exploiting this in this case. So what Apple has done with the iPhone is they patented every tiny little feature. They have thousands of patents covering this thing. And that's fine, it's a strategy. But what they want to do is every time they try to enforce one of these patents on a tiny feature, they want to conflate that tiny feature with the entire phone. And they talk about the value of the phone, and the phone is great, and we should win because the phone is great. And that's a problem, right? It's how many people know when I talk about the painter Seurat, famous for Sunday in the afternoon at La Grande Jatte? Everybody's seen this. So it's like they patented a bunch of, say, a group of dots of paint. But what they want is they want the value of the whole painting. And that can't be right. So I'm kind of concerned that the Federal Circuit is buying this, and there's a lot of sympathy. And it's not just the Federal Circuit. There are a lot of very loud voices, including even some in Congress, who have this idea that if I have a patent that covers any portion of a product, well, hey, I've got the value of the product is what's at stake here. And that can't possibly be right. For example, here the slide to unlock covers a screen. And, well, it's funny that Apple says, well, the slide to unlock thing must be basically the value of the phone, because in the design patent case, they said it was the shape of the rectangle that was the value of the entire phone. I don't know how many different things are the value of the entire phone, but I guess it's it's like I'm saying, every little feature, in fact, encapsulates the value of the entire phone. It's sort of how do I want to put this? It's almost like a quantum mechanical version where every single patent covers the entire phone simultaneously, and it's only when you look at a particular patent that we figure, oh, well, that's the one that actually covers the entire phone. It gets me the value of the entire phone. So it's a disturbing trend, and I think it's important that we not let the Federal Circuit distort obviousness law in order to support this strategy, right? We need to be realistic about this. If you're going to patent small features, then you have to suck up the consequences, which is that, frankly, the value of an individual patent is not worth all that much. A patent on a tiny feature doesn't have that much value to it. I mean, Judge Posner pointed this out in his opinions in the Motorola cases. There's another thing going on here, too, which is I also find disturbing as someone with a computer science background. It's almost as if, so Arthur C. Clarke, the science fiction writer, I'm going to just paraphrase what he said, any sufficiently advanced technology will eventually appear to be magic. And I think that there is, to the Federal Circuit, there is some level of, well, we don't understand this, therefore it must be great and really inventive. It's as if technical ignorance is now really the standard for inventiveness, and it bugs the heck out of me. So let's take again the slide to unlock, because it's the clearest example. We have, on one of the pieces of art was swipe to the right to unlock, with a thing mounted on the wall which actually had the tracking of the finger. And the Federal Circuit says, oh, well, why would you combine a thing on a wall with a thing in a phone? And the answer is, in graphical user interfaces, that's exactly what you do, right? A disembodied graphical user interface is just that. There are books on graphical user interface design, papers on it, conferences on it, and it has nothing to do with what it's embodied in. And again, Apple has a design patent, more than one, on graphical user interfaces that are just disembodied screens without devices. And yet, in this context, all of a sudden, it matters. Ironically, in the secondary consideration part, the Federal Circuit said they looked at survey evidence about whether people cared about the slide to unlock feature. Survey had to do with 7-inch tablets. Well, 7-inch, the whole problem we're talking about is pocket dialing, right? That's the original problem that Apple said they were trying to address. So the idea is that the slide to unlock feature keeps you from accidentally dialing while it's in your pocket. Well, if you can fit a 7-inch tablet in your pocket, you've got really big pockets. And yet, for that, in that context, the Federal Circuit's like, oh, well, that's fine. That's close enough. But again, technical ignorance becomes elevated instead of simply looking at, instead of looking at what's really going on here, which is a minor innovation. The other thing so that's just my personal frustration as a computer scientist, well, a former computer scientist, which I will toss out there. We haven't talked much about the injunctions. Carl talked a little bit about it. It's kind of important. So the injunction issue never got a real hearing. Samsung never had a chance to appeal it because what happened was they had the injunction decision, then the merits panel in this case actually reversed the district court so that those patents were now invalid, which mooted the injunction. Samsung asked the Supreme Court to acknowledge that by vacating the injunction decision, which the court declined to do. Then the en banc court came out of nowhere and decided, oh wait, no, those patents are not invalid, and now the injunction issue is live again. So it's a strange posture. I've never seen anything like it, but it does, that's how we're back at the injunction stage. And it's the same thing that I talked about at the beginning, right? Apple has a patent on a small feature, but they want to conflate it with the whole phone and get an injunction on it. Before eBay, we had this problem of any patent infringed, you automatically got an injunction, no matter how small the feature. There are many patent owners who would like to go back to that regime. Apple is apparently one of them. They may not be when they're on the receiving end, but they are right now. It's really important that eBay stay where it is because it is a problem to allow patenting of a small number of dots of paint to cover the entire painting. That's not how this is supposed to work. You're supposed to patent what you actually, what you invented, and if that's infringed, you get the value of that, not the entire painting. So the injunction issue is going to be important. I'm a little concerned about the case just because procedurally it is a mess. The Federal Circuit has just mangled it. We, CCIA, when I was at CCIA, we put in a brief back after the en banc decision came out saying, you guys really should consider opening this back up for briefing because, it doesn't look good and this does not give confidence. Essentially what they did was they, as Samsung pointed out, it's a redo. They said, well, we don't agree with the panel, so we're just going to redo it. They even, the appeal, the en banc court is supposed to be a question of, I believe, substantial importance or something, I forget the exact wording of the standard. Apple, in its reply brief here, has said, well, there's no important, Samsung hasn't pointed to any really important question from the en banc decision, which is kind of crazy because by definition there has to be one, right? Otherwise there wouldn't have been an en banc decision. This whole case is nuts. So that part worries me that the Supreme Court may just say, we got enough on our plate, we don't want to deal with this mess. Or they may say, oh my God, what is the Federal Circuit doing? We need to step in. I don't know which way they're going to go. I guess I'm hoping that they will say, oi, we have to do something. So those are just my rambling thoughts on this. Again, I think this case is a lot more important than people may think. It's not just the twisting of obviousness law, and it's not just the watering down of, trying to go back to the pre-eBay injunction rule. It's this whole, the battle is really for what are patents going to cover? Are they going to cover what they say they cover, or are we going to allow the conflation of the tiny with the entire thing?
Can I, real quick, I'd like
Absolutely.
to piggyback on what Matt said since we've opened up injunctions a little bit. I want to agree with Matt, number one, that it's not only the forefront of technology to patent really little things in giant, really complex technological things, but it's becoming a strategy. And it's troublesome in two respects, and it's very troublesome that the Federal Circuit is buying into it and doing so consciously. And if you haven't read the en banc opinion, I'm imagining that most of you haven't, they essentially said, most people who have a little tiny feature patented in a really much more complex thing, they can't satisfy the standard. So we're going to change the standard to give those people injunctions, which is a really, really, really backward way of thinking about whether an injunction is justified. It is, if injunctions are basically about preventing irreparable harm, that is, harm that can't be remedied by damages. So when you're going to say that slide to unlock, infringement on slide to unlock because Samsung put it in its product or something similar to it, that's had such a devastating effect when you to enjoin it. You're making a pretty big ask, and the court is just sort of meeting, it's kind of meeting the facts to get to the result rather than, just evaluating it and saying maybe injunctions just aren't appropriate for really teeny features of a much bigger product, especially when you can take that threat of an injunction for the teeny feature and get somebody to redesign their entire company around it in the practical world. Another thing that was kind of troublesome about the way the federal court did it, and this is kind of what we're talking about when we talk about the slide back to eBay, where injunctions, the pre-ABA world was kind of like the Federal Circuit allowed injunctions fairly readily. As they said that, the public interest just generally favors the awarding of injunctions. So that whole factor, one of the 4 factors you have to satisfy to get an injunction, is just kind of satisfied in a patent case. That's not particularly careful to the spirit of eBay, which is kind of like saying, no, all 4 factors matter in every case. But when you consider the case in which this comes up, smartphones, and you consider that these are some of the most technologically advanced devices in the world that fit into the palm of our hands. I mean, you think about the computing power that you have, and think about the connective capabilities that these little teeny things do. There's a lot more at stake than just the interest between Apple and Samsung. The public interest is in ensuring that these things remain cheap, that people be able to invent them in the future in a technologically and economically feasible way. And those are much more complex than, a patent owner should just, the public interest just sort of favors protecting intellectual property, is essentially the way that the Federal Circuit's gone. And I mean, that's not probably the kind of thing that the Supreme Court by itself would consider kind of important, but I think that Matt's right. Like, at the end of the day, the Supreme Court's got to look at the extremely troublesome procedure that's resulted in some pretty troublesome opinions, and hopefully just say, well, let's just take a look at it and see where we come out with a more fulsome process.
So this case, in large part, I think it's clear, is about how courts decide obviousness and sort of the rules for how that issue gets decided, both how judges and how juries decide obviousness. So my question to you all, I mean, we've obviously touched on this already somewhat, but is why should non-lawyers care about this in a practical sense? Are we just talking about, burdens and question of law versus question of fact? But how does this really play out in the real world for either consumers, for practicing companies, et cetera?
And I think Carl and Matt did a great job already touching on this, but consumers and everyday persons should care about how these cases are decided, not because everyone wants to read 300 pages about legal standards, but because patents and intellectual property, and when I talk about patents, I'm talking about not just exclusive rights associated with them, but the critically important limitations on making sure that patents are novel, useful, non-obvious, are driving our innovation economy. And that innovation economy isn't just about the smartphone in your hand and the price of the very fun products that we all have and carry around with us. It's about the products and the innovations that are affecting everyday health, safety, local economies, not just our national economy, right? It's about the farmer in upstate New York and everyone else that depends on that continued progress to see advancement in all of these areas, whether it's pharmaceuticals, 3D printing, manufactured technologies, or it's the internet economy. And so when we look at, and I love the dots on a painting analogy, because these seemingly seemingly small issues, while they look small and they look minor, lead to, or could lead to, if the Supreme Court doesn't step in and look at the bigger picture of what's happening, an erosion of the patent system and its purpose to make sure that it is promoting progress rather than hindering it through imposing economic restrictions and exclusive rights where they don't belong.
Yet I'd like to recapitulate just a little bit, because we sort of talked about a bunch of things, in seriam. But yeah, I mean, I think that it's bad. Number one, it's just bad to have obvious inventions. That limits what everyone else who's trying to create something can do. It's anti-competitive, because patents are a very, very, very powerful weapon. And they're rightfully so when you've got a real invention. But when you have an invention of questionable value, and then you extend, if you can take that and really aggressively enforce it, it becomes a really big problem when you're talking about fostering competition and protecting the other people in the economy as well. And yeah, and I think it really boils down, because the future development of this country, I think you have to admit, is going to be tied to our ability to continually innovate. And we're talking about steps that individually may not seem that huge, but collectively taken and spread out over time, erode a system that was working pretty well to produce the most amazing economy the world's ever seen, and it really makes you wonder how well we'll do in the future if you can't enter a new realm and you see industries already dominated by these major players that are going to be they're so powerful they can just stave off any potential competitor. I mean, it's not just an antitrust problem; it's a patent problem, because they can use their patents to harm everybody else and prevent anyone from getting close to them, and just to build a moat around their products, and that doesn't help anybody.
So I think one point about patent law in general that a lot of different people in a lot of different fields have recognized is that the application of the patent laws sort of varies in how it really plays out in different fields and different industries. So what I want to ask is, what in your view are the fields that where obviousness is sort of most important in terms of a well-functioning patent system in industry? And in particular, I'm thinking of, for example, the software field. I think there are a lot of folks that have said obviousness is, among other doctrines in patent law, particularly important in protecting the normal progress of innovation in the software field. And I'm curious if you all agree and why that may be the case.
Yeah, so in software, I think you're right. Obviousness is particularly important, especially because programmers and software developers are trained to use what's been done before and build on it. So, I mean, there are actual books of design patterns. So these are abstract ways of dealing with problems that that you can then implement depending on the problem. You can tweak and adjust. But, we're trained to actually abstract away the problem and then modify. So you take, there's a joke about, it really could apply to mathematicians or computer scientists, but so you take a computer scientist and put him in a room with a bucket of water and a fire. Well, he'll take the bucket of water and put out the fire. The next day, they take the same computer scientist, put him in a room, put the bucket of water on a table with a fire. Room will burn down. Why? Because the computer scientist will take the bucket of water, put it on the floor, and now it's a solved problem. So he's done. This is what computer scientists do. They take existing stuff, tweak, put together. So obviousness is really critical in software to be able to figure out whether they've actually come up with something new or they've just done what, frankly, programmers have done for whatever it is, 30, 40 years at this point. Taking existing stuff, putting it together, tweaking, and moving on, which is why many in the software area are not thrilled with patents. So that's waxed and waned over the years, but generally speaking, most programmers, I think, are not thrilled about software patents. But so it really has to be vital for that. As far as other fields, unfortunately, I don't know. Maybe somebody else can talk to that.
Yeah, actually, I'd like to add to that. I think that aside from the software industry, this has far-reaching effects. For example, pharmaceuticals. You have situations. There is a known phenomenon called evergreening, where brand companies will get patents to extend coverage on drugs for incremental advances that may not actually be all that significant, and be able to charge high prices to consumers. You have changing the salt form of a drug, or going to a specific enantiomer of racemate. All these things are fairly kind of well known now in technology, but allowing someone to get patent protection on these kind of trivial advances, I think it has significant problems. Again, outside of the software industry, I think this is a patent system problem that affects all industries.
I'll just add one example from Public Knowledge's brief. We walked through in our brief a variety of different fields and industries that would be affected by the deterioration of robust obviousness doctrine. And one is 3D printing, which is obviously an emerging field in the last decade. And there's an example that we point to of a patent. Somebody tried to get a patent on just the concept of printing 3D objects in chocolate. So you obviously have 3D printing, that's in the prior art. You have objects made of chocolate, that's clearly in the prior art. And so the combination of the two, 3D printing and chocolate, somebody tried to get a patent on. I think that's a good example of the kind of combination of previously existing elements that obviousness law is designed to prevent, because it doesn't contain that sufficient inventive spark to justify the patent monopoly. I'm curious, so one commentator wrote that the Federal Circuit en banc opinion in this case, quote, radically changes the law of obviousness and amounts to a revolt against controlling Supreme Court precedent. I'm curious if you all agree.
It wouldn't be the first time that accusation has been levied against the Federal Circuit, nor would it be the first time that that accusation be levied accurately. And this is another instance. I mean, you can look at the last 20 years of Supreme Court versus federal jurisprudence is this push-pull between the Supreme Court saying, we think IP really should be this way, and the Federal Circuit saying, no, we just know it better. So we're just going to work around whatever you say, and we're just going to sort of rewrite things. So I mean, I think you can see that in two respects here, and I think that comment refers to the obviousness change. And keep in mind, when you read the opinion, they go out of their way to say, no, we're not changing the law of obviousness, and we're totally not avoiding KSR. We totally respect KSR, but, and then everything after the but is the opinion. Everything else is just throat clearing. And the same thing with the eBay standard. I think these are fairly conscious workarounds, because there's a real distaste for some of the way that, among some of the members of the court about how the Supreme Court has handled some of these issues. So I think it's fair. I think it's fair to call that this case, and also just the kind of timeline as we've been leading up to this. And I think you can see that attitude trickling up to the Supreme Court. I think there were something like, there might have been 10 patent cases on the court's docket the past year. They've taken a real interest in the Supreme Court's docket. They've taken a real interest in redirecting the Federal Circuit, and this case is of a piece of that. And I think these issues are so fundamental. That's one of the things that hopefully the court will take a look at about it.
Yeah, I would just add to that I think this is an example where the Federal Circuit has tried to effectively walk back from KSR. Prior to KSR, they had a rigid teaching, suggestion, motivation test. So that motivation to combine had to be explicit in the prior art. If it wasn't, it probably wasn't obvious. KSR said, no, that's not right. But yet here in this en banc majority decision, we have the court again requiring that there be some specific motivation to combine. So I do think that it's in definite conflict with Supreme Court precedent.
So I'd like to open it up if anyone has questions from the audience. So while people are thinking, I'll ask one more. So it's interesting in patent law. Obviously, you have the huge question in the last few decades of patent trolls and potential abuses by non-practicing entities. On the other hand, you also have very large companies, in this case Apple versus Samsung, owning huge patent portfolios and asserting them against potential competitors. So What do you all see as the implications for competition in terms of why obviousness and potentially the law around injunctions as well, it really matters for real world competition in the economy?
Well, the thing is, patents are intended to protect the inventor from, give them some space to get something new on the market because we want this new thing out there, right? That's the point. The point is, it's not a reward. I know there's some commentators who argue that, but I really don't think that it is. I think the point is to enable someone to invest in the technology. The problem comes when competitors use them tactically, and it's hard to blame them, but it really isn't about being ripped off. Having somebody else try and market your invention, it's, well, they're a competitor and I can slow them down with my patents, or if we have this new injunction standard, maybe enjoin them completely from selling this product that is taking away some of my market share. That can't be good for competition, right? The point of competition, obviously, is products compete on the merits, people buy the ones that they like. I think that Android phones have really, frankly, the competition between iPhone and Android has improved both phone lines. Samsung's phones are obviously better because the iPhone's out there. I think the iPhone has improved substantially because of innovations in the Samsung phones and other Android models. Competition is, generally speaking, a good thing, certainly in markets like this one. Patents are, by their nature, anti-competitive. That's the whole point. The point is to restrain competition in this case so that someone has a chance to get something out that they invested in without somebody else being able to come along and simply, harvest the fruits of all that time and development. I think what we're seeing is a disturbing trend, and it's been happening for some decades, of looking at patents as something in and of themselves to monetize or use tactically, rather than, patents have always been used tactically, I suppose, among competitors, and there have been some instances of attempting to monetize them, but certainly there's a big movement lately of thinking of them as assets that we must get money from somehow. So we have patent trolls who have this idea that, I have a patent, therefore I should be able to make money off of the patent. It's now disembodied from the invention and whatever product it was supposed to result in. It's just now a money-making asset. And then we have larger companies who are using them tactically to say, I've got market share here, and so in order to get these products off the market or delay or force them to get rid of some features, I'm going to sue them for patent infringement. Again, has nothing to do with the actual purpose of the patents. It's just, these are just now tools for really arguably anti-competitive behavior.
All right, we have some questions. Yes?
So assuming the Supreme Court doesn't take up the case, what's the significance of this decision being en banc versus simple panel view? Does that have more weight for future decisions?
Any thoughts?
Yes.
So an en banc decision it's binding on every subsequent Federal Circuit panel. So any 3 judges would not have the power or authority to reach a contrary conclusion. Based on the facts of the case, maybe they could come out differently. But in terms of the legal framework, they're really confined to that unless the court again takes it en banc and changes the law.
And I should add, for folks who are not well-versed necessarily in patent litigation, unlike almost every other issue where you have the regional circuit courts, to be clear, the Federal Circuit Court does have national appellate jurisdiction in patent law over the entire country. District courts from all across the country, when they appeal patent cases, go to the Federal Circuit, and that means that district courts all cite the Federal Circuit, no matter if you're in California or Maine or wherever. So it really is a mini Supreme Court in that regard. Yeah. I'm sorry. Do we have another comment?
I want to add one more thing just about en banc, just in terms of Supreme Court procedure. Like you said, the Federal Circuit's in a unique position because it has a national jurisdiction. So the court usually sees its job as uniformity, just ensuring that everybody in the country is playing by the same rules. So they usually wait for a conflict between one circuit and another circuit. You never see that with the Federal Circuit case. So while the fact that and another thing that the Supreme Court often does is wait for cases to percolate. They might see one decision that isn't quite clear on a particular subject, and maybe they'll say, well, maybe that circuit will clarify its law and, do our work for us so we don't have to get involved in this case, because they have very finite resources. But when it comes to the federal circuit, you have national jurisdiction, so you have no conflicts, and when they go en banc, that means they're done. And it's, they've come to his final conclusion is they're going to do. And so in a way that actually makes Supreme Court review more facilitated, a little easier, and should attract the court to the case a little bit more. And if they have trouble with the opinion, they're not going to be able to count on the federal circuit to fix it in subsequent cases. This is the law for whatever it is. And it isn't just the most clear opinion as to what that en banc law really is. But that's grounds, again, to attract the court, not to repel the court.
Yes.
I'm Bob Schwartz. I think pretty obviously the oldest person in the room. And I recall back, at least through the late 70s, the Federal Circuit, or what was called then, basically encircling the Supreme Court on so many issues, just going back, back to particular areas where the court had sent the case back and said, no, you got it wrong, and then deciding a run of cases and making it difficult for the Supreme Court to make further corrections, and finally giving up over the years. And as you point out, lately they haven't been giving up. They've been taking case after case and doing this. And in addition to their national jurisdiction with respect to patents on core copyright issues, if a case has a patent claim at the beginning, even if it gets tossed, it remains a case that goes to the Federal Circuit on core copyright issues, rather than, which then purports to apply to the law of whichever circuit it actually should have gone to. Like the weather, everybody talks about the Federal Circuit, but nobody does anything about it. I don't recall any controversies over nominations to the Federal Circuit. Has any of you, in your more particular practices, observe the situation of how people get appointed and whether there should be more attention to placing people on this court?
Any thoughts about that?
I think there's real tension about the Federal Circuit as a court, because the justices are prized in the nomination process most of all for being good IP litigators, or IP or judges who have dealt with IP cases a lot, and or patent cases a lot. And IP litigators tend to come from this technical background, and so they just kind of have a different DNA than different kinds of courts. And they come up from their own culture. It's kind of like the bankruptcy bar. They got their own courts, they got their own culture, they got this whole thing that they've developed, and I think it's somewhat an ecosystem that is reinforcing upon itself. I haven't seen a move to nominate different kinds of judges to the court. I think there's a kind of presumption that, like, well, the senators don't want to touch it because they don't understand it. It's the magic black box. The Federal Circuit's a magic black box to a lot of people. Like, whatever they do, I can't read their opinions, I can't understand what they're saying. It's all this stuff about, Claim 19 of the patent and what maps onto this. And it's a whole different doctrine, and so it's really hard for a lot of other people to break into. So it's not something that has attracted a lot of attention. But you do kind of wonder, as patent policy becomes more of an objective of Congress, and patent reform becomes more of an objective, whether or not they should be looking at that a little bit more, the composition of the Federal Circuit. I think it's a good point, because it's not that they're necessarily bad judges. They are IP judges, and they love their IP. They love it, and they don't necessarily love the procedure, the regularity that you get in other courts that really care about being courts first, because they're not experts in anything in particular.
Well, not all of the Federal Circuit judges are IP specialists. I don't think Judge Wallach wasn't. I don't think Judge Reyna was either. Of course, Judges Chan and Stoll and Judge Moore were. It's hard to know if it's the composition of the court or the isolation of the court, or insularity, I guess is a better word. The fact that they deal with all the appeals, there's nobody to challenge them. One thing about having multiple circuits is that you do get some sort of crosstalk, right? So that you've got maybe Judge Posner saying some stuff, talking with, and now I'm blanking on some names of other great judges, but judges in the Ninth Circuit or in the Second Circuit, and you've got some, they can at least talk to each other through their opinions, and you get some sort of influence going on. But the Federal Circuit doesn't have that. There are, it's what is it, 11 judges now, or 12? I don't know. 12.
Active judges.
And so they can talk among themselves, but that culture will sort of, I think it's possible to get at least some cliques and some groupthink going on within the cliques, which is what we saw really in this en banc case, right? We've got the panel, which is going, well, we did this work, why are you redoing everything that we did? And then you've got the other group, the majority, that's saying, well, we think that Apple did some really cool stuff, so you're being mean to them and we're going to fix that. Although, I don't know that they can be honest with themselves that that's what they're doing, but it's pretty clear that that's what they're doing. So there might be, this was an interesting idea, having one patent court. Might be nice to spread out the work a little bit, but that's just my thought. I'm not the only one who's proposed it by a long shot, but.
And I'll just add, as a recovering former congressional staffer in the room, but it is incredibly difficult to get members of Congress to not just understand these issues, but to prioritize them when we think about how we not only organize the courts, but how we bring judges onto the courts. And so, particularly, in the Senate, given the last few months of nominations, hearings, and issues that we've seen in non-judicial contexts, but I think part of the problem is that it's very difficult for members in the Senate, but all of Congress, both chambers, when they look at a case and they say, this is two incredibly large companies, Apple and Samsung, and they look at cases in silos, and they don't look at the entire ecosystem, and how is the ecosystem functioning, and what is the makeup of the court, and the setup, and the rules associated with patent appeals affecting these incremental steps, and how does that translate not just to Silicon Valley companies or companies located in New York City, but to the small businesses in my district and to the mom and pop retail shops on Main Street. And I think that's a challenge that we as a trade association have tried to take on with very incremental progress, but it's one that needs to be continued. And I think that this case is not the only one that highlights that maybe it's time for a discussion about how we understand the courts in the IP context.
I just want to add one thing. One of the challenges with the Federal Circuit is that despite having exclusive jurisdiction over patent appeals, it also has jurisdiction over a number of other types of cases. International trade cases, veterans claims, money claims against the government. So you have some judges that, like Judge Wallach, for example, and Judge Reyna with kind of international trade backgrounds. And then you have judges like Judge Newman, Judges Moore, Stoll, Chen, Judge Laurie, that have more kind of patent technical backgrounds. Senior Judge Lynn, for example. So you have, I think, a fair amount of diversity at the Federal Circuit. So I'm not sure that there's, I guess, and maybe I misunderstood the question, but I'm not sure there's an issue so far as into the nomination process. I think that, based on the court's jurisdiction, that the composition is somewhat appropriate, though I definitely quibble with some of the decisions that they issue.
So I'll just add, as another recovering congressional staffer, when I was around for the final years of deliberation before the America Invents Act, the major patent reform bill that passed, I believe it was 2011, maybe 2012. And there was some discussion at the staff level. It didn't go anywhere, obviously, and it wasn't ever seriously on the table, but there was some discussion at the staff level about whether or not the creation of the Federal Circuit was a mistake in the preceding decades. But of course, then there was also a recognition that given how entrenched the Federal Circuit is in patent law, there was no realistic chance for changing that. And I do, public knowledge certainly believes that it's important to have judges, especially on the Federal Circuit, who understand not just the IP owner perspective, but the user perspective, the consumer perspective, and that the intellectual property obviously needs to be balanced. It can't just be about constant maximization of protection.
And if I can just say one thing, 'cause I've been pretty hard on the court today, and we should be realistic. Ellen just talking about being a congressional staffer reminded me of this. The Federal Circuit does have to deal with every patent case, every technical area, everything from software to pharmaceuticals to farm equipment to, you name it. No single person has expertise in every area that's going to come before them. So it's an enormous ask. I think my criticism is less that they're not experts in these areas, as there seems to be a lack of some unwillingness to acknowledge that perhaps the lack of expertise might be influencing their perception of the importance of the inventions. It's difficult to look at something, if you really, for me, I was in grad school for some time and, out in the field designing user interfaces for products, not for mobile devices. It doesn't seem that magical to me. But, that's my experience. For someone who doesn't have that experience, I can imagine it probably does. And I see stuff that, in other technical areas, I go, wow, that's amazing. How do they do that? And it may turn out that that's, like a magic trick. Maybe it's really not all that hard. The challenge of the Federal Circuit certainly is a difficult one. But it would be nice if there was some awareness of the fact that, well, maybe this just looks amazing to me, but I need to dig in a little bit to figure out whether it's really, I need to look and not just take my own instinct about whether it's magical, but actually look at the art, which is, I think in this case, we had art that was pretty clear that the stuff was already out there. But we've got some judges who appear to be saying, but it looks really cool, so it must be good, must be inventive. And that's what's concerning me.
We have just a few minutes left. Any other questions? Okay, well, hearing none, I'd just like to thank all of our panelists. I think it's been a very engaging discussion for me, at least, and we will see how the Supreme Court comes out on this one. Thanks, everybody.